Welcome to, or welcome back to, the Agatha May Detective Agency. I'm Agatha May, and it's time for another episode about Troy Taylor. For those of you who need to catch up, search for Troy Taylor on my channel and you'll find the episodes I've made about him. I figure that's an easier way to tell you to find it instead of me saying I'll leave links and then completely forget to leave the links. I want to say thank you to all of you who are financially supporting the channel. And if you'd like to be one of them, there are links in the description for membership. And those links will actually be there because they're automatically added every time I upload a video. Otherwise, I'd forget to link them too.
This video contains descriptions of disturbing scenarios that some viewers may find distressing. Viewer discretion is advised.
In our last episode about Doughboy Troy, we learned that he's now claiming that he's proved his innocence. And he says the only reason that Georgetown County didn't retry his first case is because they didn't want to risk ruining their reputation. Well, that sounded absolutely asinine to me, so I thought I'd look into his cases and see what I could find. In September of 2003, the Georgetown County Sheriff's Department in Georgetown, South Carolina, received a report from a counselor with the Georgetown County Department of Social Services, letting them know that one of their clients had told them that Troy Taylor had molested him in 1991. So the Sheriff's Department began investigating. Victim number 1 was 12 when he was molested by Troy at Troy's house when Troy was 21. Then another victim came forward. He said he was also 12 when Troy molested him in 1988 when Troy was 19, and it also occurred at Troy's house. On December 5, 2003, Troy was arrested and charged with 2 counts of a lewd act on a minor and released the same day on $10,000 bail. On November 22, 2005, Troy was arrested on a third charge, which was second-degree criminal sexual misconduct with a minor. The next day, he was released on a $20,000 bond. Victim 3 was 11 at the time of the abuse and Troy was 29. The victim testified that the rape happened in 1998 and was also at Troy's home, but it was after a church youth group to the beach. The youth group had returned to the church to take showers, but the showers there were full, so Troy took 2 of the boys back to his house to use the showers there. On November 29, 2005, Troy was arrested in Williamsburg County and charged with second-degree criminal sexual conduct with a minor and was released 2 days later on $50,000 bond. He would later also be charged with kidnapping that victim. And this was the same victim as victim number 3 in the Georgetown case. And he told investigators that the rape happened on a church youth group camping trip in 1999 when the victim was 12 years old and Troy was 30. While reading old newspaper articles about Troy's cases, the journalist made sure to point out that Troy had adopted a boy from Romania not long before these charges. Troy had gone to Romania and asked the boy's grandmother if he could adopt him, and she put him off at first, but eventually relented. The boy was 12 when he first met Troy, and Troy would later talk about that first meeting and say, "I knew that he was special." A trial was scheduled for the Georgetown charges in April of 2006, but instead of the trial, Troy entered a guilty plea on April 20th and was sentenced to 8 years with 3 suspended on each charge to be served concurrently. He was required to serve at least 85% of his sentence. He decided not to take a plea in his Williamsburg case, though, because he was sure he would win it. But on July 12, 2007, after a 3-day trial, the jury found him guilty and he was sentenced to life for second-degree criminal sexual conduct and a second life sentence for kidnapping. The sentences were to run consecutively. Now, Troy tried and tried and tried again to have his sentence vacated in the Georgetown case. He filed motion after motion, and I'm not going to cover them all, but we'll talk about the basic premise of why he thought he deserved a new trial. Now, Troy wasn't worried about the older charges, which were the lewd acts with a minor, but he was worried about the criminal sexual conduct charge. And the reason he was worried about that one is because that it was a much more serious crime, so it was the one that held the weight that earned him life in prison for the Williamsburg charges. So when Troy filed his motions, they were about that charge. And his main complaint was that the dates that the alleged sodomy occurred were changed from sometime between June and July 1999 to around August 5th through 7th of 1999. He said he had alibis for those exact dates, August 5th through 7th, but the wording wasn't for those exact dates. The wording was that the rape happened sometime around there, And in some documents, it was noted that there were times that referred to the incident as just happening sometime in the summer of 1999. Troy also complained that his attorney hadn't told him that the sodomy charge was considered a very serious offense and could lead to him getting a life without parole sentence for his Williamsburg County charge because of South Carolina's two-strike law. And every time he filed a new motion, he kept screaming the same thing. He never introduced new evidence and he kept getting denied. But he didn't want to accept what the lower court said, so he filed a petition for a writ of certiorari, which means he was asking for the South Carolina Supreme Court to look at the case and give an opinion on whether or not the decisions by the lower courts were correct. He was granted that petition, and here's the opinion of the Supreme Court that was filed on June 19th, 2013. Before I get into that, here's a little confession about how dense I can be sometimes. So I'm reading through all these court documents and coming across all the Latin they like to use. And when I started reading this, I could not figure out what the word TOAL meant. And I sat here thinking that this doesn't sound very Latin. And then I realized it was just the last name of the Chief Justice, Chief Justice Toll. So the opinion pointed out that, quote, during his guilty plea, petitioner, who was Troy, stated unequivocally that he committed the acts alleged by the state and engaged in a detailed colloquy with the court affirming that he entered into the plea voluntarily, knowingly, and intelligently, end quote. Now, I might argue about the intelligently part. And even though Troy tried to claim that he wanted to have a trial for the CSC charge and was coerced into entering that guilty plea, the opinion stated that, quote, conversely, plea counsel testified the petitioner chose not to proceed to trial on the Georgetown County charges as initially planned because prior to trial, his wife's divorce attorney provided a disc to the solicitor containing a recorded conversation in which petitioner admitted to the facts of the Georgetown County allegations. Plea counsel testified that once petitioner listened to the recorded conversation, he decided to plead guilty to the Georgetown County charges instead of proceeding to trial. At the PCR hearing, petitioner denied the conversation related to the crimes charged and that he decided to plead guilty because of the existence of the recorded conversation. End quote. So, in other words, Troy knew he was busted and couldn't talk his way out of this. And the argument that the dates changed didn't fly with the Supreme Court either. Quote, although petitioner claimed he would not have pleaded guilty to the Georgetown County charges had he known about the date change in the indictment, the record reveals that petitioner was advised by the time of the plea that the dates for the alleged CSC second had changed to August 5th through 7th, end quote. They also smacked down Troy's claim that his attorney failed him by not letting him know he could get a life sentence for the Williamsburg charges. And while his attorney did fail to tell him that, his attorney also negotiated a plea deal that would have allowed Troy to plead to a lesser offense that wouldn't come with a life sentence. But Troy didn't take the plea, and he fired his attorney. And then the rest of the opinion is pointing out that the Supreme Court agrees with the lower courts and then gives the legal reasons why. In the end, they upheld the PCR court's decision. But did Troy give up? No. On August 19th, 2013, he filed a petition for a writ of habeas corpus, which is Troy challenging the court to prove that he should actually be in prison. And he did this pro se and had the bahungus to tell the Supreme Court that they were wrong. Because I'm sure Troy Taylor, little man about town, knows more about the law than a Supreme Court justice. And once again, his appeal was denied. Because again, he didn't bring up any new evidence. He is the personification of the quote, insanity is doing the same thing over and over again and expecting different results. So in this petition, he addressed the phone call that his ex-wife recorded. And here's what he wrote. I have and continue to maintain my innocence concerning the CSC charges. The tape recording that is in question is of a conversation that occurred between my then wife, redacted, and me during the 1st of December 2003. We had had numerous conversations concerning the same data material, and I was somewhat flustered. However, I was trying to save my marriage. The ex-wife asked me about my childhood and what had happened as far as abuse, etc. I was very forthright with her and went into a very detailed account of my childhood. Again, similar conversations had already occurred between us, so I did not feel the need to preface my answers with explanations. Rather, I was short and to the point. I have continued to offer an apology to my cousin for anything that occurred between us. However, I maintain that said events occurred when I was a young teen, not an older teen or adult. And Troy inserted part of his testimony from the evidentiary hearing. Quote, Your Honor, when I was a young boy, things did happen with my cousins, and I have offered an apology to my cousin, redacted, which I will never withdraw. But to say that I was a late teenager, to say that I did anything along the lines of raping anyone, is not true. End quote. At the time of this recording, I had never been arrested for any of the alleged crimes. I had only a slim idea of what I was being accused of, and that only had to do with the lewd acts. The CSC charge did not surface until 2005. On Thursday, April 13th, when Scott had me listen to the recording, he told me that it was very damning to the lewd act case with my cousin. I told him that I was not worried as he was, but that I would talk with my parents. After talking to them, I contacted Scott. I told him that if he felt that strongly, then I would consider pleading guilty to the lewd act only to get this part of my life over with. He said that he did not feel there would be any prison time, but that they would probably try to get me on the sex registry. The conversation ended with him reiterating our plans from the meeting on the day before: show up at court on Monday, April 17th, and have as many supporters as possible to show our strength. So Troy is both claiming that something happened with his cousins when he was a young boy and a young teenager. So let's do some math here. Victim 1 is about 9 years younger than Troy, and victim 2 is about 7 years younger. So if Troy was anywhere between the ages of 13 and 15, as he claims, as a young teenager, then he was molesting boys that were anywhere from 4 to 8 years old. And based on the South Carolina code that was in effect at the time of the crimes, it was unlawful for any person over the age of 14 to commit lewd or lascivious acts upon a child under the age of 14 years. And he might have said he was planning on going to trial for the CSC charges, but that's not what happened. But I guess points to Troy for trying to gaslight the South Carolina Supreme Court. And call me crazy, but I believe a Supreme Court justice over Troy. And you know who else I believe? The victims. And Troy's statement that something happened between him and his cousins shows that he does not take responsibility for his actions. Otherwise, he would say that he did something to his cousins. And Mr. Cuckoo Nutterpuff filed for post conviction relief again on September 10th, 2015. The court responded with, quote, The application should be summarily dismissed because it is successive to applicant's previous PCR application. Courts disfavor successive applications and place the burden on applicants to establish that any new ground raised in a subsequent application could not have been earlier raised in a previous application. End quote. So Troy got another big fat denial. But was he finished? No, he wasn't, because he's nothing if not tenacious. And while that can be used as a compliment, please note that I do not use it as such in this instance. So Troy filed yet another appeal, and this time he had an attorney, but that didn't make any difference, because the same grounds for post conviction relief were argued, and the court had finally had enough. His appeal was denied and dismissed with prejudice, meaning Troy couldn't file any more stupid appeals for his Georgetown County convictions. But he was able to file post conviction relief for his Williamsburg County case, the case where he was found guilty by a jury for raping and kidnapping victim number 3. Troy argued that his trial counsel was deficient for failing to investigate, and he gave several reasons why he thought this, but the only argument the court agreed with was that his attorney failed to interview all of the boys, now men, who were on the camping trip, and he should have. Troy also raised other arguments, and he argued that his appeal counsel was ineffective and that he had new evidence. And another of his arguments was that Gail Allen Cook, who was a counselor that testified for the state, said that she wouldn't have testified for the state if she'd known then what she knows now. Her reason was that she had spoken with one of the other men who'd been on that trip as a boy, and he said that Troy never did anything to him. And she talked with the missionaries who ran the orphanage where Troy had adopted his son, and they said that they never saw Troy acting inappropriately with the children there. Now, I'm not saying that Troy or someone in his family reached out to Gail Allen Cook and told her these things, but it sounds like that's what happened. And it's just a stupid argument anyway. Just because Troy didn't molest every child around him doesn't mean he didn't molest the 3 who testified against him. That's like saying that if a person robbed someone on the street one night, then they might not be guilty if they didn't rob everyone that walked down the same street the same night. And just because the people at the Romanian orphanage didn't see Troy molest a child doesn't mean he didn't. The court found that Troy had not met his burden of proof for anything other than that his attorney was ineffective for failing to interview all of the boys who'd gone on the camping trip. So this does not mean that Troy was proven innocent. He was still under arrest when he was released from jail. All the vacated sentence meant was that he was able to get a new trial. But as we know, that trial never happened. But the reason the trial didn't happen wasn't because the prosecuting attorney didn't have the evidence. The trial didn't happen because victim 3 couldn't face another trial. 2 were difficult enough, and I completely understand that. Just reading some of what was in these documents was absolutely gut-wrenching, and I can only imagine how horribly difficult it was for these men to sit in the same courtroom as their abuser, to face him and be questioned on details about the abuse. So I admire the strength it took for all three of them to come forward and stand up to their abuser. But here's what I found interesting between the two cases involving victim number 3. Both happened on church youth group outings. But in one of his many appeals, Troy argued that he couldn't have been there for the Georgetown youth group event in 1998 because, quote, I was the pastor, not the youth pastor of LC3. We had a group of volunteers led by James and Sonia Brown, and they worked with the youth. I did not do things with the youth group because my job was to grow and lead the church, end quote. So LC3 is what Dipwad called his church, Low Country Community Church. And the website was coolchurch.com. And as we can see from this screen grab from 2003, it was totally fly. Also, Sonia's one of his sisters and James is his brother-in-law. So in the Georgetown case, he didn't do things with the youth group because that wasn't his job, according to him. But in the Williamsburg case, he freely admits that he was at the church youth group camping trip and wanted his attorney to interrogate the other boys that were on the trip. So which is it, Troy? Did you or did you not go on youth group trips? That was a rhetorical question, by the way. Speaking of Troy's church, I've been told by a very reliable source that Troy stood in front of his congregation and admitted that he'd molested the boys. Troy's attorney at the time advised him against confessing to his entire congregation, but Troy didn't listen to him. And I think that says a lot about his hubris, that even then, when he'd hired someone to represent him, he still wouldn't listen to their advice because he knew better than them. I was also told there might still be a videotape of that confession. Wouldn't that be interesting to watch? And before I wrap this up, I want to read from the very first denial of post conviction relief that was filed in 2007. And the review of the record very clearly shows that Troy's claims of innocence are made up of the same ingredients that make up a cow patty. The applicant was represented in Georgetown by Scott Joy and Delton Powers on 2 counts of lewd acts upon a minor and 1 count of criminal sexual conduct with a minor in the second degree. Attorney Joy was the applicant's primary attorney. The lewd act victims were redacted and redacted. The victim as to the CSC charge was redacted. At the time of his plea, the applicant had also been charged in Williamsburg County with kidnapping and CSC with a minor second degree regarding victim redacted, which is victim number 3. The evidence against the applicant was overwhelming as to the 2 lewd act charges. Both victims were prepared to testify at trial, and in fact, one of the victims made a special trip from his duty in Iraq to testify at trial. For this reason, the state intended to try all 3 cases successively. The state planned to present Lyle evidence in each lewd act trial to prove common scheme or plan, including testimony by another young man, redacted, who also claimed the applicant molested him in a similar fashion. The state also had in evidence a tape-recorded conversation between the applicant and his now ex-wife, which contained conclusive admissions of guilt on both lewd act charges. The state could have also presented admissions made by the applicant to Georgetown investigator Tom Digsby. As Attorney Joy explained to the applicant, there were simply no plausible defenses to the lewd act charges in light of the overwhelming evidence, and since there were no eyewitnesses other than the applicant and the victims. Even the applicant's parents could not deny that it was common at the time for the applicant and the victims to sleep in the same bed. In addition, Attorney Joy explained that the applicant's role as a pastor to the boys would likely be more harmful than helpful at trial. Attorney Joy advised the applicant that the likelihood of conviction on both lewd act charges was very high. Attorney Joy also explained to the applicant that if the CSC case went to trial, The state would have made every effort to include as much damaging Lyle evidence from the other cases as the court would allow. This would have been in addition to the victim's own testimony, which notably was later found credible by a jury in Williamsburg County. Attorney Joy and the applicant discussed the victim's statement regarding the alleged sodomy and reviewed the discovery that had been provided. They discussed a potential strategy of bringing out the victim's history and his possible motives for fabricating the assault. But Attorney Joy was not confident that such a strategy would ultimately be successful at trial. The victim's statement to police indicated that the applicant invited him to take a shower at his house in Murrells Inlet following a church-related trip to Huntington Beach because none of the showers at the church were available. Although the applicant denied the assault occurred, he never informed his attorney that there was any malfunction with the showers at the church. He also never told his attorney that he wanted to explore a possible alibi defense. Attorney Joy investigated the CSC allegations using a former FBI agent named Don Myers. Mr. Myers met with the applicant and with his family members. Mr. Myers interviewed the applicant's potential witnesses. However, each person he interviewed either could not recall anything one way or another due to the passage of time, or they recalled information that was actually harmful to the case. And there's a footnote on that that reads, for example, at least two of the potential witnesses recalled playing strip tag with the applicant at some point around the time of the allegations. Additionally, if character witnesses were called on the applicant's behalf, they might have opened the door to damaging impeachment regarding whether the witnesses were aware that the applicant had been found with a collection of pornography on his church computer. Considering all the evidence the state might present, Attorney Joy worked to negotiate a plea offer that would combine all of the Georgetown offenses and give the applicant as little prison time as possible. Attorney Joy was cognizant of the fact that the applicant wanted to minimize any time he might have to be away from his children. Initially, the applicant had not been amenable to the idea of a plea, and he rejected an offer for a plea to assault and battery of a high and aggravated nature. However, after he listened to the tape of the phone conversation between himself and his ex-wife, during which he made admissions of inappropriate touchings of both lewd act victims, he told his attorney that he had determined that a deal with respect to all Georgetown charges would be in his best interest. Attorney Joy testified that this decision was made 1 week before the guilty plea on a Thursday, and that the applicant listened to the tape in his truck. The applicant acknowledged that he did listen to the tape in his truck at some point prior to the plea. On Thursday, April 20th, 2006, the applicant pled guilty, waiving grand jury presentment as to the CSC charge. Attorney Joy testified that prior to the plea, and following a discussion in chambers, it was understood that the applicant would receive a sentence of 8 years, suspended to 5 years of active time, and 3 years of probation. This was over the objection of the solicitor, who wanted at least 10 years. By his plea, the applicant avoided the possibility of receiving up to 50 years in prison had he gone to trial on each charge. The applicant was advised of this on the record at the plea, specifically that each lewd act carried a maximum of 15 years, and that the CSC charge carried a maximum of 20 years. The requirements of 85% service and registration as a sex offender were also discussed on the record. In addition, the applicant was informed of the nature of the charges against him, the factual basis for the charges, and the constitutional rights he was waiving by pleading guilty. Although the applicant now claims that his lawyer told him what to say at the plea, Attorney Joy testified that he specifically advised the applicant to tell the plea judge the truth. At his plea, the applicant told the court that he was pleading freely, voluntarily, and without threat or coercion. He admitted his guilt under oath, and further told the court that he was absolutely satisfied with his attorney's services, that they had called all of the witnesses that he wanted to call, and that there was nothing further he wished for them to do. Prior to the plea being accepted by Judge Cottingham as freely and voluntarily made, without any equivocation from the applicant was informed that he could change his mind and enter a plea of not guilty. Judge Cottingham also pointed out that there were pending charges in Williamsburg, and he clarified although there may have been some hope of possible concurrent sentencing, another court in Williamsburg County would have to deal with that case separately in the future. At the time of these comments, the applicant had already tendered his plea and admitted his guilt. And that's where we'll stop for now, but I still have a lot more to talk about though. In our next episode, we'll start discussing some of the supporting cast of crazies that I bumped into while digging through this case. Until next time, stay safe and be happy.